Reassessing the structure and commercial nature of judicial forums in the United States. 1. Judicial entities as commercial enterprises. Contrary to the common perception of courts as impartial adjudicators of justice, evidence suggests that many judicial institutions in the United States function primarily as commercial entities. United States district courts, typically understood to be Article III courts, are often in practice Article I legislative tribunals. These forums operate under corporate structures with registered DUNS, Data Universal Numbering System, identifiers and participate in international commercial trading under classifications such as NAICS codes. These courts are also registered with the Department of Defense and hold accounts that facilitate the securitization of legal documents filed within them. 2. Financial infrastructure behind court operations. These courts utilize banking mechanisms involving depository agreements, escrow accounts, and security agreements. Clerks of court often act as signatories to these instruments, coordinating with depository institutions, many of which are registered with the Federal Reserve Bank of New York. This financial arrangement facilitates the conversion of litigants' filings into negotiable instruments which are subsequently pooled and traded. 3. Legal professionals as private debt collectors. Attorneys frequently act in the capacity of private debt collectors, particularly in foreclosure proceedings. Under the Fair Debt Collection Practices Act, FDPA, codified at Title 15 U.S. C. Section 1692, such actors must be licensed and bonded. However, while individual attorneys are often exempted via bar association protocols, their law firms are not. Many law firms operate without proper bonding or licensing, thereby exposing litigants to unauthorized collections. 4. Securitization and market integration of legal instruments. Legal filings are routinely transformed into commercial securities through a process known as securitization. Instruments such as promissory notes on mortgage loans are legally defined as securities if they have maturities exceeding 9 months, 15 U.S. C. Section 77B1. These instruments are sold in secondary markets as mortgage-backed securities, then pooled and traded as bonds on the TBA, to be announced, market. Entities like PIMCO Bonds and Allianz SE serve as major underwriters and reinsurers for these transactions. 5. Contractual nature of court proceedings and remedies. Participation in court proceedings constitutes a commercial contract. Individuals, often unknowingly, enter into binding contractual relationships governed by procedural codes. Remedies such as letters rogatory, formal requests issued under international law pursuant to 18 U.S. C. Section 1781 and Rule 28B of the Federal Rules of Civil Procedure, may serve as instruments of redress. These tools empower individuals to assert contractual terms and obligations within these tribunals. 6. Implications and legal recourse. Understanding the commercial and contractual dimensions of judicial proceedings is essential for challenging improper practices. Individuals must be informed of the commercial instruments at play, assert their rights via formal legal correspondence, and demand accountability through established international and federal mechanisms. Only by shifting liability and disrupting the securitization process can litigants regain equitable standing within these financialized forums.